Committee is called to order. And I first want to apologize to all of our witnesses about the delay. Unfortunately, in this line of work, there often are votes, and so all the members of the committee were caught up in the House of Commons. But we do have this room until 8:30. So what I'll propose is that we have one panelist on the first panel, and we have 4 groups on the second panel. If we combine all of the panels, and then we can have them each do their presentation, and then we can just go into the questioning, and we'll have an hour and 10 minutes to hear from the 5 different organizations. If there's no objections, okay, then without further ado, I'll call the first witnesses. They're here in person. We do have a number that are going to be coming in through teleconference. This is the Canadian Association of Labour Lawyers. We have Colleen Bauman and Peter Engelman. And will it be both of you or just one speaking?
You'll get both of us.
Both of you. Okay, so you'll have 10 minutes. Actually, did we say 10 or 7? We'll do 7 minutes, and so you can divide the 7 minutes as you see fit. Thank you.
Stop me. I hope my colleague will stop me when we hit that 4-minute mark. Good afternoon, good evening, distinguished members. It's a pleasure to have the privilege to be here and to talk to you about this very important work you're embarking upon. I'm joined by my colleague, Colleen Bauman. We're both partners in the law firm Goldblatt Partners. We're here speaking on behalf, though, of the Canadian Association of Labour Lawyers. It's a national organization representing union clients with the goal of promoting the legal interests and improving the well-being of Canadian workers and their families. We practice in the area of labor and human rights law and have extensive experience representing employees with respect to discrimination that they may face in their workplaces. And Call, I should say, is delighted that this committee was struck. There was a tremendous amount of work done a long time ago, 12 years ago, by a task force chaired by Beth Bilson. I recall having the opportunity to appear before that task force on behalf of 2 clients at the time. They did some wonderful work. If you get nothing else from us tonight, they've done some very detailed work. There's no need to reinvent the wheel. There is some fine-tuning, and I hope we get some questions on some of that. In any event, what the Bilson report recognized was that the federal system for resolving pay equity was not working. Very few employers were tackling the issue voluntarily. Those that did the right thing were then at a disadvantage with some of vis-a-vis their competitors. And those employees fortunate enough to have strong union representation were the only ones who made gains under the former law, or current law in part. I personally prosecuted 2 very lengthy cases, one as counsel for the union at Bell Canada on behalf of the telephone operators. The case took almost 10 years. We were at the Supreme Court of Canada twice. It was just full of technical arguments, and at the end there was a settlement and there was some pay equity for the telephone operators, but it was a very lengthy legal battle. And the other case I was involved in is a case for the Human Rights Commission prosecuting a complaint against Canada Post. And that case started before my firstborn was born. And I think he was 18 or 19 when we finished, and that was before the tribunal, and then it was appealed up to the Supreme Court of Canada. That is not how to do pay equity. That does not help women and men working in female-dominated jobs get equal pay for work of equal value. So the great thing about the Bilson report is she had the experience from Ontario, she had the experience from Quebec. They looked at both regimes. They made some improvements in my respectful submission on them. Unfortunately, the report was never implemented, and the system went from bad to worse. And my colleague, Ms. Bauman, will talk about PSECA. Some key principles very quickly. Pay equity or equal pay for work of equal value is a basic human right. That was recognized by Ms. Bilson. It's very important that it be dealt with separately from collective bargaining. 2, the coverage should be across the federal jurisdiction. This includes federally regulated employers. It includes the House of Parliament. It includes the federal government, its agency, Crown corporations. And importantly, the Bilson report says we should look at employees of federal contractors, and I think that's very important. It deals with structures of employers, lines of business that require special consideration. far too much time was spent on technical arguments, fighting over what things mean. You need detail in your legislation. It recognizes the importance of maintenance of pay equity, and this has been a problem in Ontario. It's been a problem in Quebec, and perhaps we can talk about that. And the need for a truly independent pay equity commission and an independent pay equity tribunal. You need experts to deal with these issues. It goes further than other pay equity legislation in addressing disadvantage of visible minorities, Aboriginals, and disabled people, in addition to women. That may be something you want to phase in as a phase 2, get it right for women, get it right on systemic gender discrimination first, and then move into phase 2. Colleen, I'm over time.
Thank you, Peter. Good evening, and thank you for this opportunity to speak to you tonight. In the brief time remaining, I wanted to provide some comments with respect to the Public Sector Equitable Compensation Act, or PSECA. In Call's view, this is a regressive piece of legislation that should be repealed. Rather than proactive pay equity legislation envisioned by the 2004 Pay Equity Task Force report, PSECA is a step backwards from the concept of equal pay for work of equal value and significantly interferes with the rights of federal public sector employees by denying them human rights protections for systemic gender discrimination in pay, contrary to Section 15 of the Charter. And as you know, PSECA applies to federal public servants, was passed in 2009, but is not yet enforced because the necessary regulations under it have never been promulgated. In the meantime, the pay equity complaints of federal public servants have been left to languish largely in limbo. Those that have been filed have gone to the Public Service Labor Relations and Employment Board. This in itself is problematic given that the board has no expertise whatsoever in pay equity. PSECA is fundamentally flawed and puts in place measures that severely limit access to pay equity protection. And some of these problems include the high threshold for a female predominant group, that's at 70%, compared to 55% for groups of over 500 employees in the equal wage guidelines under the Human Rights Act. The introduction of a market forces criteria to assess the value of work performed by employees. And market forces, of course, is something that's commonly accepted as perpetuating pay inequities between men and women rather than resolving pay inequity. And the fact that pay equity complaints are to be adjudicated by the PSLRB instead of pay equity experts. And the imposition of an incredible high standard of manifestly unreasonable in order to have access to adjudication. The cumulative effect of all these various measures is to whittle away at the concept of pay equity so that it has no meaningful content left at the end of the day. PSECA also inappropriately imposes an equal obligation on the bargaining agent and the employer to provide equitable compensation and makes bargaining agents jointly liable with the employer to pay compensation. And this shared obligation fails to recognize that pay equity is a human right, not a benefit to be sought at the bargaining table. PSECA is inconsistent with the recommendations of the 2004 Pay Equity Task Force report. It cannot be remedied and should be repealed. It is also Call's recommendation that complaints of federal public servants should not be going to the board. And we thank the committee for this opportunity to speak and welcome any questions that you may have later.
Thank you very much. We'll now go to the second organization, the Canadian Centre for Policy Alternatives. We have here with us Kate McInturf, who is a senior researcher. You have 7 minutes.
Thank you. Good evening, and thank you to the committee for inviting me to be here today. My name is Kate McInturf, and I'm a senior researcher at the Canadian Centre for Policy Alternatives. So today in Canada, our daughters are as likely to attend universities as are our sons. But we are in danger of failing to deliver on the promise of education because those girls are going to grow up and graduate to a pay gap unless we act now. Karma doesn't cut it. Doing nothing, leaving pay to the forces of the market gives us what we have today, a widening gap between men and women's rates of pay. Let me repeat that. The gap in men and women's full-time wages is growing right now in Canada, not shrinking. The cost of continuing to underemploy and underpay women in our workforce is high, at a time when we can little afford it. Closing the gender gap is a key part of the return to strong growth in Canada's economy and security for Canadians. The OECD projects that narrowing the gap between men and women's employment in Canada by 50% could contribute an additional $160 billion to our economy by 2030. Research published by the World Bank suggests that closing the gender wage gap could be worth the equivalent of 10% of Canada's GDP. That's not nothing. Not to our economy, not to women. So what causes the gap? One of the major forces contributing to the gap in men and women's wages is the unequal distribution of unpaid work. Women in Canada continue to spend twice as much time on unpaid care work as do men. As long as there are only 24 hours in the day, that is going to put an absolute limit on the number of hours of paid work that women can take up. And more to the point, it also limits the kind of paid work that women can do, which is one of the reasons that we see a concentration of women in occupations with hours that accommodate their unpaid work, occupations like nursing, teaching, and retail sales. We also see an overrepresentation of women in part-time work. Women are 3 times as likely to work part-time as are men, and nearly a third of the women who work part-time cite family care as the reason that they do so. Finally, the kinds of work that women have historically performed without pay, caregiving and housework, are undervalued. Early childhood educators, home health care workers, and housekeepers, all highly predominantly female occupations, are amongst the lowest paid occupational sectors in our economy. Occupational segregation is itself a major factor in creating the pay gap. Men and women tend to work in different occupations. Now, that in itself should not necessarily lead to a pay gap, not if we valued the work of women and men equally. However, it does, and we evidently do not. Further, we also see that as the share of women in a field increases, the wages in that field stagnate or decrease. That is why leaving it to the magic of the marketplace will only produce more of what we already have, unfair and unequal rates of pay. Finally, not all women are the same. The wage gap widens for Aboriginal women, racialized women, for women with disabilities, and for immigrant women. This is in spite of the fact that immigrant women as a group, for example, are more highly educated than non-immigrant women as a group. Aboriginal women have seen one of the fastest increases in their levels of higher education amongst any group in our workforce, and yet the wage gap actually gets larger for Aboriginal women with university degrees, as opposed to those with only high school degrees. Finally, women with different levels of education respond differently to policy interventions. Some, for example, benefit from longer periods of parental leave, particularly women with lower levels of education, while women with higher levels of education do not. These differences can exacerbate and complicate attempts to narrow the wage gap, and it means that the policy solutions must address these intersecting dynamics of discrimination and income inequality in order to close the gap. So what does work to close the gap? Well, the first step in fixing a problem is realizing that you have one. Systematically tracking wages is essential to addressing that gap. The second step is to do something about it once you've found it. Wage-setting policies are particularly important in expanding the choices available for women at every income level, but particularly for low-income women. Higher minimum wages and collective bargaining narrow the wage gap where it makes the biggest difference for women with lower educational levels and lower earning potential. Next, women's double burden of unpaid work has to be addressed. There's comprehensive evidence from across OECD countries, including Canada, that paid parental leave and affordable and available childcare narrows the wage gap. Most parents in Canada are working parents. The majority of women with young children are working women. By choice or necessity, that is the reality. When childcare is available and the cost does not consume a third of median female wages, which it does in almost every city in Canada outside of Quebec today, then women are able to make real choices about how and when they return to paid work. Finally, research also finds that policies that support work-life balance are not in themselves sufficient. The impact of these policies is shaped by social attitudes. Where societies value women's work, progressive family policies can have a significant impact on the pay and employment gap. Where they do not, women continue to struggle for fair treatment in the workplace. That means that any policy or legislation aimed at narrowing the gap must also be paired with broader efforts to address discriminatory attitudes toward the role of women. The persistence of economic inequality across gender and racial lines is underwritten by social inequalities. The gaps in employment and wages that occur in spite of equal or even superior levels of education and experience demonstrate the persistence of underlying bias, a bias which sees traditionally male occupations as deserving of higher remuneration, which undervalues historically female occupations and work, paid or unpaid, and which puts a premium on hiring male workers. The male breadwinner model of economic and family life no longer reflects the real choices being made by Canadians. This means that social policy must be twinned with economic policy in order to ensure that all the barriers to equality are removed. The gap in pay is a complicated problem with complicated solutions. I'm wrapping up. But we do have solutions. The 2004 Pay Equity Task Force provided a comprehensive foundation for moving forward. And move forward we must, because the cost of doing nothing is too high. Thank you.
Thank you very much. Our next witness is coming to us through video conference. It's Kathleen Leahy, who is a professor at the Faculty of Law at Queen's University. Dr. Leahy, you have the floor for 7 minutes.
Thank you. Thank you very much for making it possible for me to participate in this important discussion. I am going to focus on 5 points that I think are becoming of increasing importance as the continued existence and growth of various wage gaps has been more and more completely documented over the intervening 12 or 13 years that have passed since this was a major issue for the government. The first point that I want to emphasize is that while it is much more complicated to come to grips with the impact of visible minority, Aboriginal, immigration, and disability status on gender wage gaps, they are rapidly compounded when those intersecting, so to speak, characteristics come into effect. I've included for your reference, a set of tables that I have been developing that try to really pinpoint these kinds of issues. And Table 11 shows that, for example, the visible minority and Aboriginal women gender wage gaps can be as high as 38 to 47% on a national level. This really escalates the barriers that are faced by women who have these multiple barriers and forms of discrimination. So I think that there is sufficient information on this to bring this into the picture now as this committee continues its deliberations on this issue. The second point is that I would like to definitely reinforce and dwell upon the fact that we now know through extremely comprehensive research carried out in many different countries around the world at different levels of development that pay gaps are not just a sort of here and now problem. They are an intergenerational problem. They are a systemic problem. They are a problem that affects everyone in the whole country, their whole lives. And this is something that begins before young women even become old enough to earn any money. It becomes pronounced when women go into education and find that their part-time work, their summer jobs are not paying as much as men. They have to borrow more money for their higher education. They take longer to pay back their loans because they have lower wages when they do graduate and go into their full-time earning years. They find that when they go to take maternity leave, they're often not able to take full advantage of the income security programs that do exist because employment insurance will only replace 55% of their wages, and their wages are much lower than young men's. And so, of course, paternity leave is going to be popular because it's going to be more profitable for families. Not that that's a bad thing that men will take paternity leave, but it just underscores the fact that women are disadvantaged even in an area where their needs are supposedly a priority. And as their lives unfold, they will have less ability to form savings to get them through emergencies and periods of unemployment or to augment their maternity leave incomes. They will have less ability to save for their own retirement, even though public and private pensions have been being cut back more and more. And not surprisingly, the more children a woman has, the less likely she is to be able to re-enter paid work in a way that will really maintain an upward trajectory. Women's peak earning years are shorter and have lower incomes in them than men's do. This is a systemic problem, and it affects everyone all the time. The third main sort of structural point is that our whole tax transfer system is now built around the assumption that women are not going to be able to maintain themselves with sustainable incomes. And at last count, there was at least $25 billion being spent annually, including this year, to subsidize women's unpaid work in various ways all through their lives. But less than $2 billion is currently spent federally to fund the child care expense deduction. That's how lopsided things have become. Table 7 shows that the new child benefit is actually going to exacerbate the male breadwinner model, because child care expenses will eat up the largest part of the child benefit for single parents and for dual income, equal income, and low income couples who are both in full-time work. The only people who will really be able to use the child benefit for what it is intended to improve the quality of life for children are going to be those who have parents who are living on one relatively high single income, i.e., usually the male breadwinner model. Table 8 demonstrates that, in fact, we are imposing a tax on women who are single parents or who are in dual earner income couples, because they literally have to pay on top of their usual taxes on their employment income a tax in the form of child care expenses that they simply cannot recover in any other way. The fourth point is that pay equity laws and child care subsidies could actively grow the economy of Canada in very specific ways. Table 6 demonstrates that even if just one province, the province of Alberta, were to engage in partial and beginning pay equity adjustments, that would produce between $5 billion and $4 billion in federal revenues more each year, beginning in 2016. If you were to multiply that impact across the country and then take the provincial tax and revenue effect into consideration, you would be seeing even larger amounts being generated, and over time this would accumulate. My last point is that comprehensive research has also made it perfectly clear that countries that do systemically support women's paid work as a priority and prohibit wage discrimination, occupational stratification, and other forms of workplace discrimination have more durable economies, because on the whole, individuals and households have more durable sources of income, are less vulnerable to downturns, and now provably are intergenerationally transmitting not discrimination, but gender equality, including economic gender equality. Those are my comments. Thank you.
Thank you very much. And by video conference, our next witness is Daphne Terrasse, the Dean of the Edwards School of Business at the University of Saskatchewan. Welcome, and you have 7 minutes.
Thank you. Thank you for inviting me to speak. I just want to note that I spoke a number of years ago against PSECA myself, particularly Section 36, which banned people from seeking the help of either employers or unions in addressing pay equity concerns, and so I thought that legislation stunk, if I could put it in so many words. My greatest value today, though, will be to raise ideas and thoughts that might not have been presented before and to suggest some labor market matters about which the House of Commons ought to care. I come to you as an industrial relations researcher, and for the past 6 years have been dean of a vibrant business school and a U15 research university in a province that's doing very well. And my thoughts have been shaped by many, many sources and provoked by continued contact with multiple generations. So I see thousands of young people every decade, and I'm always spotting and watching trends. Although it remains very relevant, pay equity has virtually vanished from research. I searched all articles in Google Scholar on pay equity in Canada and elsewhere. It took 7 computer screens of articles before I found a single post-2004 publication. Almost all of the work that you have been relying on and all the work that we talk about has been done between about 1988 and 1992, the heyday of studies of pay equity. So it's quietly slipped out of vogue, but there have been major achievements that have been documented. For decades, I would submit that almost as much money has been paid to consultants who tried to provide the data during very sophisticated eras of policy capturing, regression lines, comparators, and so on, and I've been guilty of that myself. Almost as much money was spent on consultants as went into the pockets of the ladies who most needed the adjustments. Companies, employers were quick to study and very slow to act. As the courts got involved, the creation of an adversarial tone came to pay equity like never before. Perhaps there's more work to be done, there's more policy research to be done, there's more acting to be done, but the window seems to have been closed on research about it. And I just wanted to point that out. It's quite perplexing to me. The final push for perfection and justice, which we're engaged in right now, is the hardest to achieve. And I want to raise some other issues that we're in early days on, and I suspect we're actually in fairly late days on the pay adjustments with pay equity. We've got the legislation largely in place. We should extend it to other groups. In my own university, 2 years ago, all women on faculty received a 2% adjustment to wage plus additional increments based on years of service. This was done quietly, without fanfare and without pushback, particularly from males or unions on campus wanting to allocate differently. This is a victory for pay equity, a victory when employers simply and quietly acknowledge that there is a gap and address it. Without consultants, without major studies, they looked at their statistics and they said, let's just fix it, and let's fix it permanently, and let's monitor it. Some of the best studies ever done on wage gaps within academic life show that there's a mysterious 5% gap even after every possible variable is controlled. And what I really enjoy is that my university simply eliminated that mystery gap. For all its difficulties in measuring and implementing, I submit to you that pay equity is one of the more simple applications of human rights thinking, because pay is fairly easily measured. It's easily recorded, whereas other issues like hours of work, having to work overtime to avoid benefit-rich claims for new employees. There are a lot of pressures on existing employees to put in unsociable hours of work. There are problems with access to dental plan, orthodontics for children, seeking access to medical care for aging parents and dependent children during normal working hours is a horrific problem, as doctors rightly have reduced their hours of work to give them more humane lives. It's pushed a problem onto all people who are working. people are perplexed by how to have babies and also show the type of loyalty to employers that's required to progress through the ranks during those very, very important high income earning years. And there are an extraordinary number of workplace issues that involve things other than pay. Pay equity between men and women is important, but so too is pay equity for immigrants with non-British accents, visible minorities, First Nations, and others in need of your attention. One of the most disturbing wage gaps in Canada is actually between white men and Canadian-born visible minority men. A gap of 17% in 2005. Black men, as compared to white men, fare worst of all, with a gap of 24.3% in the public sector and 35.5% in the private sector. When all variables are controlled for in studies using the most rigorous possible techniques, the gap remains, the mystery gap remains over 11%. But they found very little difference in the within women data. It was within men data that there was a huge gap, and comparing, let's say, First Nations females against males, huge gaps. But the within female gap was not as alarming as the within male gap. Very interesting study. Here's what I'm curious about. Do women like me, women who have achieved full equity in all aspects of work and life, do we retire earlier than comparable men? And are we just that much more tired, having birthed and raised children while reaching for that golden ring of equality? Certainly we know from many studies that when we are paid the same, we are subjected to higher performance standards. So we work very, very hard for the same pay when we get it. I don't know many women my age, and I'm almost 60, who are lawyers, doctors, and other professionals who work the same long and hard hours as their male counterparts. We are an exception. I see women like me either retiring or going to part-time, what I would consider quite prematurely. And what are the implications of different retirement practices of men and women, and how do they carry through to issues affecting seniors? We know that women live much longer lives than men, but if they commence retirement earlier, because of the pressures on them that we have not solved, are we stretching out their pensions and saving and leaving them in rather dire straits?
Professor?
Are they also more likely?
If you could come to a conclusion.
I will.
Okay, thank you.
Okay. A final point that I wanted to make is absolutely no studies have been done on the age of marriage and the difference, the 2.5-year difference between men and women, so that it makes more financial sense for women to be the ones that leave the workplace because their husband is 2.5 years more advanced in their career. So there is a logic that has never been studied that actually I would suggest to you might have a significant effect on the wage gap, and it's a missing variable, and it's a very interesting one. Thank you.
Very much, Professor. If you want to elaborate, you can do that during the questions and answers or through written
Sure.
brief if you wish. Okay, so we'll start with the question. Oh, sorry. Oh, Margot, my apologies. Margot Young, we have from the University of British Columbia and Allard School of Law, and she's a professor there. And Dr. you have 7 minutes.
Great. Thanks a lot. It's my pleasure to meet with the committee, and I think this is incredibly important work that you're doing. Today I'm going to speak to the notion of pay equity as required by Canada's commitment to equality, both at an international and domestic level. And I begin just by noting, as we all know already, that pay equity is a fundamental human right. And so this makes the focus of this committee of the utmost importance. Rights unavoidably signal three things. First, they are non-negotiable demands. They are demands that should get immediate attention. Secondly, rights obligate governance by definition. And so the response to the claim of a right has to be legislative, mandating, and administrative implementation. Finally, finally, rights demand what are called accountability mechanisms. These are things such as legislative timetables, clear outcome objectives, review procedures for compliance, and enforcement procedures for non-compliance. And until on all three dimensions, the federal government has fully and properly responded to its own recognition of pay equity as a human right, it is simply not in observance of this right. On a political front, talk about gender equity, slogans like "It's 2015" are purely empty rhetoric without such things in place as proper and full pay equity law. And so for a government that is committed to, for a government that indeed has promised to prioritize gender equality, pay equity reforms are essential. I won't go over the data. I think we all know that it's dismal. The gender earning gap for women in full-time, full-year paid work is now larger than it was in 1995. Canada ranks 80th in wage equality in a recent survey by the World Economic Forum. Remedying these injustices, or this particular injustice, demands a comprehensive and effective set of pay equity measures. So my presentation has three parts, all of which flow from this recognition of the rights character of our obligation to ensure pay equity. First, I want to talk briefly about Canada's international commitments and the recognition that Canada has failed under these international commitments with respect to pay equity. Second, I want to talk very briefly and on the surface about our domestic constitutional commitments that should oblige the government to pay equity legislation. And finally, I want to just point the committee to some useful resources that are available online for clearer articulation of a strong feminist perspective on pay equity obligations. So, with regard first to Canada's international obligations, it is clear that Canada is obligated under international human rights law and labor law to achieving pay equity. And I'm going to detail just a few of the sites of this obligation. Most critically, the International Covenant on Economic, Social, and Cultural Rights guarantees under Article 7 the right of everyone to equal remuneration for work of equal value. Article 2, to go on, of the Equal Remuneration Convention, ratified by Canada in 1972, states that every member, so that's Canada, shall, by means appropriate to methods in operation for determining rates of wage, promote and ensure the application to all workers of the principle of equal remuneration for men and women for work of equal value. And then the convention goes on to detail the way this can be done through laws or recognized national machinery, through collective agreements, or through a combination. Again, to move to another site, Article 11 of the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW or Women's Convention, adopted by Canada in 1981, mandates that states take all appropriate measures to eliminate discrimination against women in the field of employment in order to achieve the benefit, it further details, of equal value. And the convention is clear that this is a positive obligation that the state party take all necessary measures to achieve pay equity. The Beijing Declaration and Platform for Action, the sort of articulation of these obligations, also provides the positive obligation placed on governments to guarantee the right of equal pay for work of equal value. Article 2 of the Discrimination Convention, again from the ILO or AO, ratified in 1964, takes a parallel stance. Every member of the convention undertakes to declare and pursue a national policy designed to promote equality in employment. Now, it's not gone unnoticed in the international community that Canada has failed to meet these obligations. In March 2016, just last month, the Committee on Economic, Social, and Cultural Rights wrote that it was concerned about the gender wage gap in Canada. And in section 22 of its concluding observations for Canada's periodic review, recommended that Canada develop and implement a comprehensive national gender equality policy that would include specifically implementation and improvement of legislation to achieve pay equity for women. The previous year, that is in 2015, the Human Rights Committee at the United Nations, doing a periodic review of Canada under the International Covenant on Civil and Political Rights, expressed similar concern about persisting inequalities between men and women in employment. They were specifically alarmed by the pay gap in Canada for women, noting that it was more pronounced in particular provinces, that it disproportionately affects low-income women, particularly minority and Indigenous women, and they recommended that Canada strengthen its efforts to guarantee equal pay for work of equal value. To ensure, they went on to say specifically and precisely, that the Pay Equity Task Force recommendations were all implemented. So I conclude this first part of my presentation by just repeating then that there's strong messaging from the International Human Rights Committee that we're failing on our international human rights obligations. So the next
you're out of time. Sorry about that. Yeah, we'll move.
Okay, so I'll just conclude by saying I'm happy to discuss the charter obligations and what the nature of pay equity being a human right concretely demands going forward.
Okay, thank you very much. And we will now go to the first question. It's for Ms. Zarevitz for 7 minutes.
Thank you, Madam Chair. I'm actually going to share my time. First, I just want to say thank you so much for the outstanding presentations today. Sorry we're rushing you, but know that all your words are very important. I also want to encourage you, because there's a lot of new information today. Please send in your presentations. It's going to take more time than the 30 minutes we had to really digest, particularly from those who are on the teleconference. There's no way I can digest all of this in a short period of time. I do have 3 quick questions. Peter, you started off by saying you're very supportive of Belson and her recommendations, but you said there might be some adjustments that you might want to recommend, if you can talk to that. Second, I'm just going to ask them all at once. Professor Leahy, you said that countries that support pay equity have more durable economies. If you can point out maybe 1 or 2 countries that you really think that we might want to look at and study as we're moving through the rest of our committee hearings and moving towards legislation, I'd be grateful. And then Professor Taras, oh my gosh, so much new information. What I would want to know from you, if you I'm sure you're very familiar with the Belson report. If you could say to us, here are 1 or 2 specific recommendations that I would also add on the table for your consideration in terms of moving forward on this pay equity legislation, I'd love to hear from you. Thank you so much.
Okay, perhaps I'll start. And I don't really take issue with anything in the report. I just worry that trying to do everything at once may be too ambitious. So, for example, when pay equity was implemented proactively in Ontario, there was a phase-in of certain issues. There was a phase-in on employers, starting with large employers having requirements before smaller employers. You may look at something like that. There's definitely, when you're looking at expanding the jurisdiction, going into new areas, and I'm not saying this is wrong, I'm agreeing with it, when you're looking at dependent contractors, as opposed to simply employees. When you're looking at the federal contractors program, very ambitious, great idea. It will cover universities and others. But if you're going to do that, you need to have enforcement mechanisms. Because employment equity under the federal contractors program, when you have 2 people, and this is what it used to be, 2 people reviewing it, there's no real compliance. So if you're going to set yourself out with ambitious targets, ambitious legislation, there has to be money behind it to enforce it. My concern with intersectional discrimination, and you know, I've argued many human rights cases, and many of them have involved intersectional discrimination, so it's no question it exists. But again, it's something you might want to phase in. Get it right first. I mean, it's easier to deal with occupational segregation and standard pay equity issues and gender predominance and then phase in. There's a lot of work to be done here. and you need experts to do it. And that's a key, and it's not clear to me that the Bilson report was saying segregate this from the Federal Human Rights Commission. I would strongly urge you to do that so that this receives the priority it needs. Otherwise, it gets folded in to the Commission with other money. It needs a separate agency, and it needs a separate tribunal, because we wasted so much time having to prove that there was a gender gap in Canada and having to prove other things that, were ridiculous. So you have proactive laws, it'll help. And anyway, those are a few comments.
Professor Leahy?
Yes, on the question of other countries, I would say that it would be very useful to have a good, close look at Sweden and Norway as early pioneers on taking the kinds of steps that have to be taken all together, including the child care piece, including the early childhood education, the anti-discrimination laws, and so on. Now, I warn you, no country is perfect. It seems to be almost an unwritten rule that if a country has a high level of equal pay, they're going to have some other deficiency, maybe a high level of occupational stratification, as is the case in Sweden, or other deficiencies. So no country has it right, but a lot of countries have it much more right than Canada has ever dreamed of having. I would also put Quebec on the list because all of the detailed micro-simulation analysis that I've been doing in the last several years makes it clear that Quebec, with its proactive mechanisms for pay equity combined with its proactive child care subsidy system and the subsidized nature of child care resources, has produced a higher level of labor force participation and reduced the gender wage gaps. Another country that would be useful to look at would be Spain, which, although it had tremendous challenges after the recession, began to do both pay equity and child care investment, early childhood education programs, and remarkable results have been obtained. I would also suggest that you take a look at the new Obama executive order, which is including detailed information on wages paid by large sector employers, because if the data were to be filed by employers, literally by, not by name, but by the numbers and the demographic characteristics of different employees, and vast amounts of data were therefore available, it would make the whole compliance process much, much easier, and I think it would move everyone along more quickly to recognizing and then taking steps to solve the problem.
Professor, well, I think Dr. Terrace was the third one, and there's only 1 minute remaining.
Sorry.
Gosh, okay, I'll be fast. I'm very familiar with the Bilson report. To me, the devil in the report is in the details. I found that there was a very strong element in that report of prescription on exactly how the committees would run, how the committees would be set up. It privileged pay as a type of committee. We've already got occupational health and safety. I would put an onus on employers to work with employees and develop the mechanism that best suits them. There are a lot of non-union employee representation forums that could roll pay equity into a discussion of racism, of harassment, of other things. I don't know why there would be a privileging of a certain structure of a pay equity committee. And that was my only objection to the report, is I've never seen a report create such an imposition of a structure on one workplace issue, but not hours of work, not benefits plans, just pay equity. So I would be happy to see it less prescribed.
Thank you. And I'm sorry to be cutting you short, but I want to make sure all the questions get in before the end of our time. So on that, our next question will be to Ms. Gladue for 7 minutes.
Excellent. And I want to echo my colleagues' comments. I'm so thankful that you're all here and you're your presentations were excellent, and I especially want to say hi to Kathleen because I was a Queen's alumni myself. So my questions are going to continue on the theme about if we take the 2004 report and we look at trying to implement it, there's 15 pages of recommendations. So my question is, what do you believe the priorities are? And I liked the comments about, large employers before small employers, maybe leave the dependent contractors for later because it's complex, do the women equity before intersectional. I think those comments are good, but within the report elements, we've heard legislation is one of the first steps, that the complaint and enforcement resolution is important, and that the pay equity plan that the employer has is important. So I'm interested just to hear what you think the priority should be.
If I can just start by just saying I'm just concerned with Dr. Teres's comment about it being too prescriptive. One of the problems we had, and one of the things that led to multiple extra months of litigation, was the Equal Wages Guidelines 1986 were not prescriptive enough. And so what happened was we had, Bell Canada, who had done this wonderful voluntary pay equity study, then disowning their own study and saying it didn't meet the standards of this section or this section. I mean, it was bizarre, and that only happened when they started to realize what it was going to cost to actually close the gap. But so you've got to, there's a fine line between too prescriptive and not prescriptive enough. So I think what was happening, and I think Dr. Bilson's report was more prescriptive because at the time we were arguing the Bell Canada case and had been to the Supreme Court of Canada twice. So be careful there. I think one of the keys here, and all of the speakers have talked about the fact that the gap is growing again. And the problem is that some of the maintenance provisions in the Ontario Act are not good enough. And one of the things the Bilson report does is it talks about the need to revisit. And I think what she's suggesting by way of maintenance is stronger protection than what we see in both Ontario and Quebec. So I think there's some positives there.
What about from Kathleen? What do you think? Yeah, Professor Leahy.
Go ahead, Professor Leahy, go ahead.
Yes, sorry. I didn't turn that. Proactive responsibilities, and I agree, starting with the largest employers first. But I think that there also needs to be some mechanism to empower people who are at the whim of their employer in defining the comparable groups to be able to invoke some sort of outside expertise of some form, and I have not myself seen an effective mechanism in any jurisdiction, but invariably the most vulnerable workers are compared according to their employers' choices with people who are, for example, summer lifeguards, and really inappropriate comparisons, and there's really no room, and the whole gender hierarchy in workplaces is such that a lot of people become silenced and really frightened to speak up during pay equity periods of adjustment. And I do agree that better monitoring and having this being a continuing obligation is something that really needs to become part of the culture of business management.
Okay. What about Margot Young?
Thanks. I think I'm going to reiterate at a sort of abstract level many of the points that have been made. I would caution about jumping too quickly to the conclusion that detail is a problem. I think, in fact, the litigation over this shows that the absence of appropriate detail and specifications has been a problem. But let me begin just by saying then that a proactive scheme is universally regarded as required and as a feature that was deeply problematic about existing and proposed pay equity schemes. Secondly, the need to deal with issues of ambiguous terminology and no guidance on methodology seem to have been of critical negative importance, and so there needs to be some detail about those. And finally, I would say the enforcement procedures are critical. So it doesn't really matter what protections you have in place if there's inadequate enforcement. And effective enforcement requires at least formal formal mechanisms and sites with individuals and offices that are responsible for that enforcement. It requires adequate funding for those assigned the enforcement task, but also for individuals, particularly those who are disempowered within the workplace, to proceed. And I would include within that funding for assistance, and so that you're not leaving this simply up to individuals. And then the monitoring is a key expansion of the notion of enforcement.
All right, very good. I have to pass this over to my colleagues, so you can ask your question. Sorry.
Okay, and Professor Leahy, I find it very interesting because I recognize, and I just want to talk about the child care benefit and how that could possibly be a negative effect on women. I would think that if anything, it'd be a positive thing because it's putting more money in their pockets. And I don't understand, if you could explain to me why that would actually have a negative impact by receiving more money. I just want to see what the correlation is there.
The correlation simply is that when it comes to deciding who's going to go into paid work and who's going to do unpaid work, the person in if there's a couple who's going to be pegged to go into the paid work is going to be the person who can earn the higher income. And because that is disproportionately male income earners, then women become responsible for doing the home care work. And then when money is put into the hands of women to help close the household budget gap that will be present in many, like at least the lowest 40% of the population, you're into a situation where we are literally subsidizing women to stay home and care for children in circumstances when they may, by virtue of their education or their current employment opportunities or all sorts of factors, actually prefer to be in paid work. And this is something that is really beyond question in terms of the data that is available. More and more women are going into unpaid work either to care for their children's children or to care for their own children, and it's because they simply cannot earn a living wage that can compete with the effect of the various child care subsidies and unpaid work subsidies that permeate the Income Tax Act, the employment insurance structures, every fiscal statute in the country. There are over 170 provisions that provide either tax or direct benefits for women who are engaged in unpaid work.
Thank you. Unfortunately, we're out of time on this question. We do want to make sure everybody gets a chance, so we are moving to Ms. Benson for 7 minutes.
Thank you very much for all the presentations. This was it was really good at starting to bring some of the pieces together. And of course, I know that you appreciate we're trying to be practical and move forward something quicker rather than later and feel sort of the weight of that, of doing something considering nothing has happened. So I just have a couple of questions. I think this is for you, Ms. Bowen, and that is, you made a comment about it might have been you or your partner, about an expertise. Actually, it might have been Mr. Engelman, the expertise in pay equity, because we have heard that term used, and I don't really know what that is. Like, what is it actually an expertise? Yeah, just if you could say a little bit more about that.
Sure. Well, there are a number of consultants who have been doing work on pay equity in this country, predominantly in Ontario and Quebec because of the proactive laws, but elsewhere as well. So, for example, in the federal cases, because we had to educate panels that had human rights backgrounds but not pay equity backgrounds, someone like Pat Armstrong, who's a fantastic expert on women in work, talked about the development of equal pay law and as through time equal pay for work of equal value, and then proactive pay equity. She certainly testified. A fellow by the name of Paul Derber, who was the head of the Human Rights Commission's pay equity unit when they had a pay equity unit, and Paul has worked both with the Quebec Tribunal and the Commission and the Ontario, so has some knowledge of those areas. Then there are a number of pay equity consultants who have worked on pay equity plans outside of just the big consulting groups and developed gender-neutral plans, because it's so important that the evaluation plan capture the value of women's work and that it really be gender-neutral.
Okay.
And quickly to that, I mean, pay equity can be very, very technical.
Right.
And so it is not exactly the same as human rights law in some other areas. And that's where I think sometimes you see boards that lack that expertise needing to spend a lot of time to be brought up to speed in terms of technically how to do pay equity properly.
Okay, great, thank you. And Ms. McInturf, I hope I got that right. I'm wondering, one of the questions we've been asking our witnesses is, and I guess I'd value, because of the research you've done, because it would be my desire that we finally step into pay equity at the federal level for both private and public sector employees, and we create legislation. When in your presentation you talked about the other pieces when we talk about the wage gap, which is bigger, but would you agree that this is an important step, and we shouldn't sort of wait to get everything right, that we could actually have an impact in women's lives if we had federal pay equity legislation?
Well, yeah, clearly, I think we need to act sooner rather than later. I wouldn't want to advocate not getting things right, but I think, an incremental implementation
that was maybe more
the most practical way forward. But as a matter of urgency, I mean, when there's been a lot of interest in, for example, women on corporate boards, women in business, but really, when we're talking about a life-threatening impact, we have to think about women who make up 2/3 of minimum wage workers. So a pay gap for a retail worker who's making $12,000, $13,000 a year can really mean the difference between food and rent or not. And that's why I would urge the committee to act on this, because addressing it has a really substantial impact on the quality of life of the lowest earning women in the country.
Thank you. And this might be this is my final question, and it's to Ms. Leahy. And I just wonder if you could, you mentioned the sort of lopsidedness of how we approach things through, I guess, federal government transfers to individuals, that it was the sort of $25 billion to $2 billion statistic you talked about, and I just wondered if you could say a bit more about that.
Yes, I actually did a research project looking at what would happen economically if all of those laws were repealed, and the result was that it would immediately increase women's average incomes by over $3,000 per year, simply by virtue of the way it would leave the individual tax transfer provisions to operate on each individual and not treat women as being bundled into a unit consisting of a usually higher male wage earner and herself. And it would be a larger bump up in terms of after-tax incomes for women with the lowest incomes. So this definitely would be a poverty reduction move as well. So I'm convinced that every one of these joint and unpaid work subsidies has an invidious effect, no matter how humanitarian the impulse behind them are. They are actually undercutting women's interests. And we have a new sector to worry about that wasn't quite on the radar to the same extent back in the early 2000s, and that is the vast growth of people engaged in paid caregiving work. They are the new sort of challenge from a pay equity perspective, because when I was doing a detailed analysis of Alberta, there were so few men involved in caregiving that it was literally impossible to identify any male comparisons within that profession. And that's where you get into trying to do proxy comparisons, trying to find some other form of occupation that can be a reasonable comparison. And if employers are allowed to choose something like, 16-year-old boys who mow lawns for $12 an hour as the comparator group, then we will not be able to solve the problem of women whose careers now are involved in caregiving for pay under usually very precarious employment conditions, which themselves push the limits of existing pay equity laws to even bring into the framework, because they're often treated as being independent contractors or self-employed and not even subject to employment laws like pay equity laws.
Okay, thank you. And now for our final question, we're going to Ms. Nassif for 7 minutes.
Je vous remercie tous pour votre participation.
Thank you all for your attendance to our meeting today. You here among us in the room and our 3 participants by teleconference. The task group on pay equity in 2004 recommended in its report that the government strike a Canadian Commission on Pay Equity and a Canadian Tribunal for Pay Equity separate from the Human Rights Commission and the Human Rights Tribunal. The creation of these separate institutions would guarantee that the pay equity regime would have sufficient resources and expertise. When the Pay Equity Act was adopted in Quebec and Ontario, they set out a pay equity plan that's applied both to private and public sector employees, and a monitoring organization and a tribunal competent in the field of pay equity. My question is, do you think that the creation of distinct organizations would be necessary to administer a proactive pay equity regime, and if not, why?
La question, I think it is important that it be distinct, both from the expertise issue, and I'm not as familiar with the Quebec approach because my experience has been more in Ontario. But one of the things I've heard as a criticism is that since it's moved to a court as opposed to a tribunal hearing the cases, there is more re-education. So when we talked about expertise earlier, I think it's important that the adjudicators be at a specialized tribunal. And I think that is important. And your other point about resources is key too, because if the resources get bundled with other human rights or other labor resources, you will lose the focus. And you will lose the ability to keep those experts and to do the monitoring work that is so important. So I do support the Bilson recommendation on both distinct bodies for a commission and an enforcement mechanism and a distinct tribunal.
Thank you. I don't know if
Can I
would answer the question, please, Mrs. Young or Mrs.
Terrace?
Taras wants to.
Okay, can you hear me?
Yes, now.
I actually think, and perhaps I've had experience being on the Arthur's Commission on the Canada Labour Code on various employment standards. And my own preference would be to handle workplace-related discriminatory practices together. I think there are bundles of practices, and I would not personally privilege pay over other issues. I would rather see a panel separate. I agree it takes expertise to understand workplace discrimination, patterns of work, but I would like to see more issues. I don't see why it shouldn't be broadened to include a number of the barriers that women face at work. And to only be able to deal with pay doesn't eliminate so many of the problems that bug us at work, that perplex us and that are almost insoluble. So I don't see them as ripped apart. I see them as part of a package of workplace practices that in their totality discriminate.
Anybody else want to answer that, or would you want to continue or share your time?
Can I jump in really quickly? And I think Kathleen wants to.
Go ahead.
Just very quickly, there are a bundle of issues to consider when you're thinking about the institutional home for a pay equity system. You want a system that isn't already burdened, because that results in delay. You want a system with requisite expertise, sufficiently, indeed very adequately resourced. You want something that's set up to be proactive with the staffing and the resources for that. You also want a guarantee of impartiality through security of tenure and pay. And those features are the ones that should guide you in your choice of where you institutionally house the program.
Yes, just a quick reference. Heidi Hartman in the United States has been involved in some very large-scale studies that have compared, on the one hand, an overhaul of an entire public sector workforce, for example, a whole state in the United States, and compared that to both the costs and the benefits and the types of outcomes for more targeted pay equity, gender discrimination focused programs. And not surprisingly, the conclusion that was reached was that the whole workforce do-overs are much more expensive and tended to minimize the benefits for the gender-based discrimination. And at the other extreme, the programs that were more directly focused at gender-based discrimination resulted in overall fewer costs but much greater impact on the specific problem of gender discrimination. So I think that that is something that is worth taking into consideration, and I can provide references to some of her studies if you wanted to look at some of the details that enter into that.
You have 45 seconds.
I might ask another question.
Unless the other witnesses wish to answer that.
The vast majority of witnesses we have met with so far have all been repeating the same message, some more vibrantly and passionately than others, that the work has done ages ago, and we need to move on and with implementing the recommendation of the 2004 Task Force on Pay Equity. Do you agree with this? And if so, is it totally or in part of this?
Yes.
Yes.
We don't have.
Yes.
Yes.
Okay, we have unanimity. Wonderful, and that's a perfect note on which to end. I want to express again my tremendous thanks to all the witnesses, both for your patience and also for your expertise and for all of your testimony. If there are things that you feel didn't get covered, please do submit briefs. I know that this was a short period of time to get this much information, but thank you very, very much for taking the time out to do that. And with that, is there the one final motion, I think?
Yes, I have a motion. I'm hoping the library will still like me after this. Just as we're starting to move towards the end of our presentations, which I know we still have a number of them, I'm wondering if the library can put together the key decision points and options within the decision points that we should be looking at as we're thinking about legislation. So it could be from Treasury Board, it could be from Labor, it could be Status for Women, it could be from all three. But what are the key decision points we should be looking at and the options within each of those decision points?
Okay, and for
in terms of legislation or in terms of the report?
In terms of, I think, I'd like to say legislation. I'd like to say legislation.
It will go to all. I'll clarify. You don't actually need a motion to do that. We can just make the request of the library.
Oh, okay.
And is there another? Yes.
Well, I would just point out that we still have a number of witnesses, and for us to be directing, the analysts to start moving in a particular direction and report at this stage, I think would be probably too early. My understanding is typically. I have the floor, actually.
Mr. Albus has the floor.
And so the whole point is that we still have a number of people to hear from. We should hear their testimony, and then we can start looking at drafting a report and then recommendations. I think for us to be picking certain elements early on when we've only heard, a segment or a few segments from the witness list. I think it's just a little early.
Mr. DeCourcy.
I certainly wouldn't want the decision options to be restrictive in any way, but I actually do think it would be helpful to kind of scope or frame some of the different points along the way that decisions need to be made. And I think part of that decision tree is or a different option from options that are presented to us as an option itself. I certainly don't think it's restrictive, but I actually think it would help in framing some of the questions for remaining witnesses as we get to the end of this. I certainly don't see it as a restrictive thing by any stretch.
Ms. Gladue?
And also, I would be interested if you could send us links to the Quebec legislation and the Ontario legislation that we've heard about so we can take a look at the language and the differences.
I think in the earlier briefing notes, whenever you see Ontario pay equity law.
Was there a link in there?
Those are hyperlinks.
They've been printing them for me, so I haven't seen those things.
Yeah. Anytime you see the blue, those are hyperlinks going to the document. So,
okay, and
I'll send them again.
In the interest of time, it sounds like what we would want the libraries to provide some kind of a framework, not so much specific decisions, like something that would just guide and put our deliberations into buckets, perhaps, so that it's a little bit easier to.
If I can say, there's nothing to stop individual members from starting to collect their thoughts in certain areas, and then when we actually sit down and actually give them direction to the library analyst as to what we'd like to see in the report and give her some greater context as what we'd like to have drafted. But those are conversations that are usually done when we're actually we've completed testimony or near completion of testimony.
Okay. Ms. Derowitz?
I mean, we obviously disagree. I mean, I don't think that.
I've never seen it.
So again, we're not looking at drafting legislation. All we're doing is saying that there are certain buckets of questions, whether it's scope or the model or the job classification. I think that we can start. It just helps us with the framework to be able to start targeting some of our questions and be consistent.
I just would suggest that if the committee wants more briefing notes, Madam Chair, then that's fine. But it did sound like the member was trying to say we'd like to start, based on the testimony we've heard, start framing a report. And I just don't think we're at that point. I'm not going to belabor the point. I think I've expressed it clearly.
And I think just for clarification, we will take Ms. Zarowitz's idea and request to the library, but make sure that it is in no way prescriptive or the beginning of a report. It's just something that can inform based on. So we'll. Okay, wonderful. And seeing the hour, it is 25 to 9. So unless there are anything further, okay. Thank you very, very much. Thank you to our witnesses, and we are adjourned.
Thank you all, ladies. Enjoyed it.